I'm Andrew Galatly, Editorial Director at GamblingCompliance. This week, lawyers and regulators from all over the gambling world have converged in Vienna, and the topic on everyone's lips has been the recent European Court of Justice decisions in Austria and Germany. At the centre of the storm has been Philippe Vlaemminck, counsel to the European lotteries, and he spoke to us today and told us that he believes the decisions have done nothing more than take us back to the future. Mr. Vlaemminck, today you addressed the conference and said that you felt the last 10 years had been a wasted decade in terms of European law with regard to gambling. Would you explain that a little further?
Well, actually, as I said this morning, in 1999 the court that provided the Lara case a very important decision, because that was the first time that they said that the member states had the discretionary power to decide about type of games, volume of games, number of operators, independently of what other member states could decide. Now, if you read the judgment carefully, they talk about discretionary power, which means, in a legal concept, a very large power to decide what you want to do. So the only thing you can't do is to become arbitrary. So you have large power. On the other side here, they say you can do whatever the others are doing. Even if another member state is having a more liberal regime, you can still pursue your own policy. Now, that means that already in 1999, the court has implicitly decided that there is no mutual recognition. It means licenses issued by any state will have no validity in another state. We knew that since 1999, so we could have started the debate on what to do to cope with this problem at that moment. But clearly, the remote gambling industry, largely driven by the willingness to have the principle recognized, did not believe the points of the court. And even in Liga Portuguese, when the court said it explicitly, they still said, no, it is only applied to Portugal. And actually we needed to wait until Ladbrokes, where it was repeated, and it has been repeated in market tools as well, until the remote gambling industry started to understand that this principle is no longer valid. So we could have started regulatory debates and discussions in 1999. That's 10 years ago. At that time, you can say there were less operators on the market. Yes, but there were already operators on the market. Don't forget that the first operator of internet gambling services was the Finnish state monopoly Veikkaus, who was already operating internet games in 1996. So I think, yes, 10 years have passed and nothing has been resolved.
Now, the markets rallied last week on the news of the Market Stoss decision at the ECJ. Party Gaming and bwin, who together make more than 30% of their business out of Germany, their analysts cheered that result as somehow clearing the merger and clearing their activities in Germany. You argue that's a misreading.
I think it is a misreading. I think the press release of the court started by saying that there was questions about the validity of the monopoly of the general lotteries. That's true. And the court has been saying that. But the court has been saying that in the perspective of how the German market is organized as a whole. They did not address the monopolies as such. They addressed the German market and its variety of issues. For instance, they were very clear that the slot machine market was actually regulated improperly. There was tolerance, there was expansion. So the most risky games, slot machine games, were more liberal than any other game. Together with a form of advertising, which actually did not even exist in Germany anymore at the time the court was discussing this, created an environment whereby they said the way that Germany has regulated this market is not proper, therefore you cannot maintain it. On the other side, if you read the judgment, they confirm in several paragraphs, and they refer to the Lara judgment, they refer to Anamar, they refer to Liga Portuguese, and they confirm what they have been saying there. One, internet is a very risky business. Two, that monopolies are the most effective tool to organize the market. They say that explicitly, I think it's paragraph 103 of Marcus Stoss, where they said, if you have a choice between a monopoly operated by a public company or operated by a private company, it is still a more effective regime to reach the objectives that the government wants to reach instead of a multiple licensing system, even with supervision. So the court has been very consistent. So how can bwin then, if you read the judgment in detail, say that this is a very good point? I think the risk is, like I said this morning, that this would operate like a boomerang. You try to get liberalization and you get a closed market. Even in the same judgment, the court said internet prohibition is perfectly acceptable and member states are entitled to take unilateral actions to stop illegal gambling operations.
You've said mutual recognition is dead, and the idea of harmonisation is also a dirty word in legal circles or in political circles in Europe now. What does that leave us with? Does that leave us with a balkanised Europe of national regulations and nobody talking to each other? What is the next political step?
No, I think that Europe is based upon a number of principles, and it has been discussed by many people this morning. One of the basic principles of European law is subsidiarity. Now, subsidiarity has to be understood in its right legal concept. What does it mean? It means that you regulate at the most appropriate level what has to be regulated at that level. Member states level, what can be regulated at member states level. But it also implies when there are essential transnational elements requiring a solution that you need to go to that higher level. That's what I call the dual step approach. You need also to sit down at the European level and to find common solutions for transnational problems. Mutual recognition is just one element. Mutual recognition does not mean that you cannot have a coordinated approach at European level. Maybe the talk this morning about enhanced cooperation between states. We talk about exchange of information, coordination of law enforcement. So there are numerous activities that can be set up. Harmonization, indeed, is by most of the member states not an appropriate word at the moment. Even the UK, I can tell you the UK has always refused to have a harmonized framework for gambling because they believe they can better do it on their own. I think harmonization is just not the right word. The matter is indeed creating an European framework in addition to national legislation to cope with the essential transnational problems. And I mentioned some of them. The need of liquidity for certain games requires cooperation because small member states cannot offer attractive games like online poker or other type of pari-mutuel games. So there is a need to resolve certain problems. The law enforcement issue has been quoted several times this morning. You cannot, as a member state alone, because you're not just isolated in the world, get the law enforcement properly implemented without the cooperation of the others. So no, I think it's just a dynamic balance between what the national authorities can do and the need for them to sit down in whatever format that has to be decided, to cooperate, to set common standards. Do you call that harmonization or do you call that regulation? Which means the Spanish presidency, for instance, came to a kind of common terms on what has to be considered as illegal gambling. There is one common definition. It's not a legal definition, but there is a common understanding, at least 26 member states, because Malta disagrees with what illegal gambling means. And I think that is very important. Cooperation, understanding, exchange of information, using the tools available, and getting indeed a proper environment.
So broadly speaking, you're optimistic that there will be some kind of political solution negotiated within the next, should we say, 12 to 24 months?
Well, political solutions at European level require time because you have different institutions involved. Only the Commission has the right of initiative in European law, so the member states can talk. They can request the Commission to come up with certain proposals that the treaty does provide for that, but the initiative is in the hands of the Commission, which is, as you know, a very broad institution. You need all the commissioners to sit down, not only Mr. Barnier, but all the others also have to sit down and to come to terms as a college. That has to go to the European Parliament and the Council, and both institutions need also in the decision process to agree. So I would rather say there is a window of opportunity because the member states want to talk. You need also the associations, like you heard them this morning, saying we believe that there is a need to create legal certainty and to walk away from the legal court cases. So there is a window of opportunity. It's now in the hands of the Commission to take initiative. I think if the Green Paper comes out, it's a very good broad stakeholder consultation. It can lead to any form of pan-European framework, but it will last, in my view, 3 to 4 years before you get it.